Welcome to the Probate Nation. Whether you are caring for your spouse as a court-appointed conservator or guardian, or with timely executed financial and medical powers of attorney, or just helping out without any of those authorities, your primary goal is to provide your spouse with the best care possible as they age. But paying for that care can present financial challenges for the spouse who needs long-term care, and also for the healthy spouse often living alone now in the marital home. In our last show, we discussed how divorce may, when the dust settles and the divorce is final, protect more marital assets for a healthy spouse and facilitate the Medicaid qualification of an ill spouse. But it was clear from that show that the process of divvying up the assets between spouses is complicated. Our show this evening continues this discussion with a look at the legal and practical consequences of divorce on estate plans, financial decision-making, medical decision-making, conservatorship appointments, guardianship appointments, and much more. We are pleased to have returning as our guests two Virginia matrimonial and elder law attorneys. They will serve as our guide as we continue this timely conversation about long-term care financing for all who may be traveling on the Virginia Living Probate train. Our first guest is the founder and principal of the Arlington law firm of McCarthy Law, PLLC. Her practice focuses domestic relations, wills, estates, and trusts, as well as elder law. She serves as a certified guardian ad litem for children, as well as incapacitated adults. And she's a member of the National Academy of Elder Law Attorneys and VELA, the local state chapter. Our second guest is of counsel to the Fairfax law firm of Cullen, Sharp, Autry, and Day, where she handles family law matters with elder law issues. She's a member of the Virginia State Bar, the Virginia Trial Lawyers Association, the Virginia Academy of Elder Law Attorneys, and the Fairfax Bar Association. She has previously presented CLE programs for the Virginia CLE, the Fairfax Bar Association, and the Virginia Academy of Elder Law Attorneys. Both of our guests have previously spoken at CLE programs on the topic of where family law and elder law overlap. Please welcome again attorneys Courtney McCarthy and Sharon Henderson. Well, guys, welcome back. Thanks for returning. Let's continue this discussion. We left off talking about beneficiary designations and jointly held property, and now I think we want to take a look at all those carefully crafted estate planning documents, which all of a sudden might come into be changed because of a divorce. So, Sharon, tell me a little bit about, does divorce impact any of the estate planning documents we may have executed when we're married?
Absolutely, pretty much all of them.
Oh, yikes.
And filing for divorce impacts them too. So, for example, if you are like many couples and you have a will, a revocable living trust, and you have a durable financial power of attorney, immediately upon filing for divorce, you can no longer use that power of attorney to do any financial transactions for your spouse. Immediately, you are no longer a trustee of your spouse's revocable living trust. And if there are certain powers given to you in your spouse's will, you lose those as well. When the divorce is final, then anything that your spouse has given to you in their will is gone. Whatever property they may have given you is no longer in effect, that part of the will. And if you were an executor of the will, that is revoked. You also, the revocable living trust as well, any property given to you under that revocable living trust, gone also. So it changes every single document. You are out.
So to speak.
Yes.
So let's talk, so you kind of got ahead of me a little bit, so let me just kind of make sure that I got this straight. So how about, let's just take a look at the will provisions. How were these impacted? How are will provisions impacted when someone gets divorced?
Well, if you were named as an executor of the will, that part of the will is revoked.
You're done for that.
And if you were receiving property under the will, that is revoked. If you were given a power of appointment, that was revoked. There's some other technical things that were revoked, but those are the main ones. Okay,
so we got that. So yeah. How about many people use revocable trust to do a lot of their estate planning nowadays. Yes. So they may have a will that's just basically a support document. So tell me how revocable trust provisions might be impacted by divorce.
Well, again, if you are a trustee, that is revoked if you file. And then if you have been given property under the trust, that is gone on divorce.
Okay. So there is some significant changes that,
Yes.
that get triggered. Whether you know them or not, you ought to be aware
Yes.
that that's going to happen.
And if you were handling your spouse's finances because perhaps they were incapacitated and you were using a durable financial power of attorney, when you file for divorce, you can no longer be their agent.
And I think folks in the audience should keep that in mind, because as that's triggered, then that means we need to put somebody in charge. And so then that becomes, sort of triggers another process that needs to be, to be examined. Let's talk about, many people do premarital or marital agreements. What are those documents?
Well, they are documents that basically change what law Virginia has in place to protect spouses. So if your spouse dies, you, under Virginia law, are entitled to a certain percentage of their estate. If your spouse divorces you, you are entitled to request spousal support if you need it, and you're entitled to request equitable distribution. So in a premarital agreement, you can waive those rights. You might, many people waive all of them. You can waive some of them. There might be a provision in a premarital agreement, for example, that you get X amount of spousal support if there's a divorce unless you've committed adultery, for example. So there's a lot of flexibility in drafting a premarital agreement. A marital agreement is one that's done after you're married, and it impacts equitable distribution, and it can also impact estate options as well.
So why do people execute such documents either before or after marriage?
Well, before marriage, they tend to be people that are over 50. They've maybe been married before, whether it ended in divorce or death, and they oftentimes have children from previous marriages or relationships that they want to each provide for, and they were willing, each of the spouses is willing to waive their rights at death, at the other spouse's death, to their property, the rights they would be given under Virginia law. So they often waive those rights, and then they frequently want to keep their income separate, their assets separate. If they're in retirement status, they pretty much earned all of their property and their retirement income before the marriage anyway.
Sure, sure. So are these types of documents enforceable?
They are, unless you did not go to an attorney who knew what they were doing. And if you fail to disclose your income and your assets, say you said, I have $2 million in assets, but you left out a $600,000 debt that you had, that's failing to disclose your assets. If, say, for example, you don't understand English very well and someone presented you with a document and you signed it not understanding what it meant. So there are some ways that you could have a court invalidate an agreement.
Okay, so I mean, I think if people are going to do those types of documents, of course they should, full disclosure is important.
Yes.
And then of course documenting correctly really requires someone to probably get a person who is experienced in that area as opposed to going online and downloading a form.
Correct.
Okay. Let's talk about conservatorship and divorce. Now we've talked about all these various estate documents, what happens when people get divorced, and so on. But conservatorship is a process we've discussed in a number of prior shows. We've had many guests on from all the various jurisdictions, Arlington, Fairfax, Alexandria, all across Northern Virginia. And, while the process is very similar, there are some little tweaks. But the key is that if you don't have a power of attorney, then conservatorship is where you actually acquire the ability to handle somebody's assets. So if it turns out that your spouse didn't do a financial power of attorney and they become incapacitated, then I guess you'd apply to become a conservator to be in charge of their assets? Is that what we do?
Yes. You certainly could.
So I think that's where we get to that particular discussion. So Courtney, what authorities are granted a conservator in dealing with the assets of a spouse who is subject to the conservatorship?
The conservatorship, the court grants if it's a spouse is being appointed for if their incapacitated spouse, grants them the authority to obtain the assets of we're going to say the incapacitated spouse, the authority to marshal those assets and manage them for the benefit of the incapacitated spouse.
Okay.
There are other authorities or other options that a court can allow the conservator to do, but they require a specific court order designating it. But for the most part, they need to use those assets for the benefit of the incapacitated spouse and no one else.
Okay, and then that's important. So you'll see in a lot of the accounting shows we've done before, you have to keep the assets separate bank accounts, and you got to report to a commissioner who oversees it. You have to be bonded. So there's a bunch of things put in place to protect those assets for the person who's at risk.
And if there's a situation where a conservator feels that they need or it's appropriate, it's in the best interest of the incapacitated spouse and maybe other family members to use the assets for someone other than the incapacitated spouse, they would have to get court authority to do it, and there's a whole process and criteria the court would consider before they would even authorize something like that.
Sure, of course, and rightfully so. In the case of a spouse who is seeking a divorce, can they also be appointed as the conservator of the spouse they seek to divorce?
No.
Well, why not?
Because there's an inherent conflict of interest in that situation.
Okay.
And so the court's not going to allow a spouse who is seeking to divorce an incapacitated spouse to be the person who has control of the assets and making decisions.
And I think that comes back to what we talked about in the first show, is begin to do that process that you've described as equitable distribution. It is inherently unfair to have the spouse making decisions for both people, and they could do it in a way that might not be in the best interest of the incapacitated spouse. So,
correct.
So if they would have to resign, I guess, if they were.
They'd have to resign and
they've
find
been
a
appointed?
successor
Okay.
conservator to be appointed.
They have to step down. Now, what can they, after they have gotten the divorce and completed whatever they're going to do as far as any sort of Medicaid application, could they apply to become the conservator again?
They could. I've actually had a case where that occurred. Slightly different. They got someone in first, knowing that the idea was going to be Medicaid divorce.
Okay.
So they got someone in as the conservator, and then the divorce was resolved. And then after that, the now former spouse applied to become the conservator for the incapacitated former spouse. And the court did authorize that.
And that's interesting. You see that happening. The spouses still love each other greatly, but they're sort of having to reshuffle that deck just because they need to do that to make it work so they can take care of everybody.
They do. And that does not happen too often, the part about the spouse
coming back as a conservator.
And it certainly has to be a situation where the parties and even family members that are involved in the case really need to be cooperating with one another for that to actually occur. If there's conflict or disagreement about it, it's unlikely that a court's going to say, the former spouse can now come in and be the conservator.
Sure. We're going to talk a little bit more about it. Let's turn our focus now to the piece that is related to the topic that we started with in the earlier show, which is we're getting divorced and we're interested in qualifying for Medicaid. Okay, so how do aging adults pay for their long-term care cost, whether in the home or in a nursing home?
Well, there's a couple of resources. Private pay, meaning coming out of your pocket from the assets that you've acquired over your lifetime.
That wouldn't last very long given the cost of nursing homes.
Well, and that's a real problem.
Yeah.
There are some people who have long-term care insurance.
Okay, that helps.
I'm seeing less and less of that occurring nowadays. It used to be a little bit more prevalent.
Yeah, we were talking about that before.
Yeah, and then there are programs, Medicaid programs for long-term care. But in order to qualify for that, you have to have certain assets and income thresholds that they're taken into consideration before determined eligible.
So Medicaid really is going to cover that an adult who needs nursing home care. Okay, so they're going into a nursing home typically. That's where it's going to mostly apply.
Well, there are Medicaid waiver programs, which are kind of beyond the scope of this topic, where people can get some Medicaid waiver programs that can provide some assistance. But when we're talking about long-term care, 24/7 nursing care,
right.
We're talking about nursing homes, and not all nursing homes accept Medicaid either. So that's another piece of it, is finding the nursing homes that do have set aside some of their beds for
Correct.
Medicaid
Sure.
patients.
Yeah, those waiver programs, while they may be available, as we did the program across the metro area, it might be that you have to wait several years before you can actually get it. So while it might be available, it's not really practically available as a practical matter.
It's very complicated.
Now, are there qualification criteria in order to receive Medicaid coverage for adult long-term care programs?
Well, there are assets. There's a maximum amount of assets that
Okay.
an individual can
Okay,
have.
most assets, okay.
And there are also some income thresholds. In the long term, we see more of the income issue when we're talking about those Medicaid waiver programs. But for the long-term care, the issue of your income really has to do with how much are your monthly care costs versus how much are your monthly income. And if your care costs are much more than your monthly income, then that's where the qualification piece on the income comes in.
Okay, sure. It's not like you get to keep your income and the government's going to pay for the whole program.
No.
No, so you still have to put your piece in and contribute.
Right, and there's a process that they go through where they'll determine what is, the term is patient pay. How much is the individual who is in the nursing home going to have to pay towards their monthly care? And it's based on, essentially it's based on what is your monthly income. You get to keep $40 for your personal needs, like toothpaste or something like that, and then the rest pretty much goes. Unless you're married, there is an option for a calculation they do for. I'm going to use the word spousal support, but it's not technically spousal support.
Well, and I want to caution our viewers that the rules, while it is a federal program, there are different rules in different jurisdictions. Okay, so Maryland and DC may approach things a little bit differently. Especially how much you can keep and how much income you can have. Courtney just mentioned $40. That happens to be in Virginia what you can have.
Right.
What is the Virginia qualification income for a married person versus a single person? Is there a difference?
So when they're doing this, and again, I'm not an expert in Medicaid, but
I understand.
When we're talking about income, they're looking at the ill spouse, what their income is.
Okay.
They're not really looking at the well spouse's income.
So it doesn't really matter whether you're married or single. It's just the person who's applying. We look at their
For
income.
the income part.
Okay.
The assets is a different ball of wax.
So are all the assets, so let's talk about that. Are all the assets counted in determining eligibility for Medicaid?
Well, they're taken into consideration, but what they will look at is there are certain assets that are considered exempt.
Right.
And I'm, for purposes of our discussion, I know a good amount about Virginia.
Correct, and that's I think from our viewers' perspective, again, as we talk about this, we're really just kind of setting the stage for the fact that you need to have someone who understands how those things all work in the jurisdiction where we are applying, and then divorce can help reshuffle that. We talked a little bit about that, but there are other tools out there apart from divorce to help us, organize how these things are presented, okay, in order to qualify for that asset limitations.
So, for example, one of the most common examples of an asset that would be exempt when you have a married couple, if they have a marital home and one of the spouses is living in that home, then it doesn't matter what the value of that home is. It doesn't matter, and they don't look at equity. They don't look at anything like that. That is an exempt resource. So that doesn't get counted in as far as how much assets you can have in your name or the well spouse's name in order to be eligible for Medicaid.
So if that house had some debt on it, we often hear our colleagues who are Medicaid specialists talk about this paying down the debt.
Right.
Because it doesn't matter.
Right.
And that's peculiar to Virginia, because in other jurisdictions, the marital home is treated differently. So it's important to know. What are some of the common pitfalls a married applicant runs into in meeting the asset qualification requirement?
So common over-resourced.
Okay.
In Virginia, as of right now, the ill spouse, the person applying for Medicaid, can only have $2,000 or less in their name.
Yikes.
Other than exempt assets. And then the well spouse can only have it's approximately $126,000 $6,240, something like that. So being over-resourced, sometimes another common pitfall is uncompensated transfers.
Okay.
Medicaid will look back 5 years, and if you gave a gift to your granddaughter, 3 years ago without contemplating you'd need care, that could be an uncompensated transfer.
And again, these rules are very, very specific. We don't want to get in, this is not a chance to plan around those different types of rules, but what Courtney mentions, is an issue, potential issue. Now, Sharon, does premarital or marital agreements have any impact in the efforts of a married applicant to qualify for Medicaid?
Medicaid doesn't really care about that.
They do not.
That's an agreement between you and your spouse, and it would have an impact if there is a contested divorce. But as far as Medicaid is concerned, they're going by their standards.
Okay, so that's important to know. Some people might think, well, I made an arrangement ahead of time, and Medicaid doesn't really care.
Medicaid doesn't care, and most attorneys who do premarital agreements will advise their clients that this is just between you and your spouse. Medicaid's another thing. Government benefits are totally different. They're not bound by it.
So Courtney, in scrambling those assets on the table between the two spouses, what are some of the advantages of them getting a divorce?
Well, so one of the advantages is that the well spouse can retain more than the $126,000, that threshold right now in Virginia, of assets. That can be incredibly important if you've got a spouse in their 50s,
sure,
or even late 40s, and they still need to try and earn for retirement or even later. So that can be incredibly important.
Of course, that makes a lot. And of course, so some of the disadvantages, we talked a little bit about some of the disadvantages about getting a divorce. You lose various authorities under powers of attorney and medical decision-making documents and so on.
Yeah, you lose control.
Yeah, and you really
over
do.
being able to take care of your spouse.
Let's turn to practical considerations as we sort of, lean on you guys for some practical thoughts. Sharon, what are some of the practical considerations if a conservator elects to divorce his spouse for whom they're acting as a conservator? What are some of the practical things we have to consider when they...
Well, if you are the spouse and you're also the conservator, as Courtney said, you're not going to be the conservator anymore because you're involved in litigation.
That's true.
It's an absolute conflict of interest.
Okay.
From what I've seen, it's the even greater problem is if there are other people, usually in the family, that have a problem with what's going on, it's going to make the idea of a Medicaid divorce much more complicated and maybe not even feasible.
Okay. Courtney, how about you? What are some of the practical considerations if a healthy spouse elects to divorce the ill spouse in order to qualify the ill spouse for Medicaid? What are some of the practical considerations?
Well, they need a successor guardian.
That's right. They got to get someone else.
They got to get someone else in that role. That guardian's going to have to get authority from the court to initiate the divorce if they're going to initiate it.
Court.
And there's going to be a guardian ad litem involved also at that point again.
Okay, so we got a bunch of fees. Well, we're running out of time here. Let's get your closing comments, okay, as we've sort of captured a bunch of stuff here over 2 nights. Can you share some sort of final thoughts, words of advice based on our discussion over the last 2 shows?
Well, I think people who have heard of Medicaid divorces have the wrong impression, perhaps, that it is a solution for many cases, and it is not the solution. In fact, what I've seen is it's very rarely used because it takes absolute cooperation from everyone in the family, and when you have a very ill spouse, a lot of times there's not that situation.
Courtney, how about yourself? Any sort of final thoughts you want to share with us?
Just again, it's very complicated. You need to make sure that you're seeking advice on what you do before you do anything.
Yes.
Another thing is make sure that you really do know what your assets are. We have seen time and time again people come in and they've implemented a plan and they forgot about a retirement account from our 401k that they never rolled over from years ago, and they're all ready to apply for Medicaid, and it's a problem.
That is a problem.
Or they didn't divide it in the divorce.
That's even a bigger problem.
Yes, because at that point then it becomes, difficult to do.
Sure, Sure. Well, ladies, thank you very, very much for taking the time to come back for a second show to talk further about this and share all these good points with our viewers. It's a great help and a great public service to the folks across Northern Virginia. Thank you again.
You're welcome.
You're welcome. You know, paying for the care of an aging spouse can be challenging, but as the needs of an ill spouse makes a nursing home admission necessary, families often turn to the government for assistance through adult long-term care Medicaid. Being married can complicate that application. As we have come to learn from the show this evening, it is very complicated to unwind the financials of a marriage. And to the dismay of some couples, there are practical consequences on estate plans, financial decision-making, medical decision-making, conservatorship appointments, guardianship appointments, and much more. There are many well-tested Medicaid planning options to preserve and protect some or all of the assets of a couple without the need of a divorce. These strategies, though, will be examined in more detail in a series of case studies in future shows. But I repeat these words of caution. Medicaid is not something that lends itself to do-it-yourself efforts. You are strongly encouraged to get advice from a qualified Medicaid attorney. And early planning, as opposed to crisis planning, typically affords more planning options, especially where you are seeking to preserve assets for your community spouse. This brings us to the conclusion of our show on divorce, conservatorship, and Medicaid. We hope you found it helpful. Replays of this show and all the shows broadcast to date, along with other helpful information, can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.